I think we've got it going, yeah.
Wonderful.
All right, I'm ready whenever you're set.
Copy that, sir. Step to the counter, state your full name for the judge, including your middle.
Brett Taylor Omler.
All right, sir. You have family members in the courtroom that are present, so I'm going to make you aware of that. I want to confirm your address. Give me a moment. The state is alleging one allegation of a misdemeanor, driving on a suspended, revoked, or canceled driver's license. What I would like to do is take a plea from you and hold your arraignment now to save you another court date to come back. So instead of scheduling you later to have to come back up to Payson, we can hold the arraignment now, but I need your permission to proceed by video, waiving your personal appearance. Do I have your permission? Do you understand what I'm asking of you?
Yeah, kind of. I don't really understand it.
All right, let me explain it to you a little better. So, if I release you out of custody today, then you go home, and I order you to come back to court in Payson on another day to stand and appear in front of me in person. Or I can hold the next proceeding right now by video to save that next trip back to court. But you would have to waive your personal appearance and not stand in front of me and do it by video like we're doing right now. So I would take a plea from you, and I'll explain all of that, but I just need to see if you will waive your personal appearance of coming back on a different court date. So like I said, I can schedule it in another month. You'll have to drive all the way back up from Phoenix and come to court and stand in front of me. Or we can skip that proceeding and do it right here, right now by video.
Let's skip it.
Okay, so then you're waiving your personal appearance to do that, and we'll do this by video, okay? All right, the driving suspended, revoked, or canceled license violations of Class 1 misdemeanor. The maximum penalty on that is $2,500, 6 months of jail, and or 3 years probation. You're not facing jail time. If that changes, your rights will change, but there's no jail time on that charge. So the penalty could be from 0 up to $2,500, because of 25 is the max, and 0 up to 3 years of probation. No jail time as of now. Your options are to plead either guilty, not guilty, or no contest. A guilty plea means I admit I committed the violation. A not guilty plea means I denied that I committed the violation or that I wish to speak to the prosecutor about the violation. And a no contest plea means I'm not admitting or denying the allegation, but I am accepting a conviction. A guilty plea and a no contest plea shows as a conviction on a criminal history. Do you understand so far?
Sure.
Okay. You have the option to have an attorney if you wish. You have some choices there. 1, you can waive the presence of an attorney. Number 2, you can hire an attorney at your own expense. Or number 3, you could provide the court good cause for a court-appointed attorney at little or no cost to you. To have a court-appointed attorney at little or no cost to you, there's 2 requirements. 1, you must financially qualify for it, meaning you must not be able to afford an attorney. And I'll send a financial questionnaire if you wish to try that. Number 2, in addition to not being able to afford, so let's presume you can't afford one. Number 2 is a good cause. An example of a good cause would be if there was jail time required of this charge. And I've informed you that there's no jail time, so that takes that cause away. So you would have to come up with another cause if there are any. If there is not any cause, then you're forced to waive the presence of an attorney or hire one at your own expense. Do you understand the 3 choices?
Yes.
All right. How do you wish to proceed regarding the attorney? Waive the appearance, hire one at your own expense, or provide the court good cause for a court-appointed attorney?
I waive the appearance
All right. So I'll be sending you.
because
I'll be
I
sending.
know what I did.
Okay. I'll be sending you a form that does the two things. That number one, waives your personal appearance that I spoke with you earlier. And number two, waives the presence of an attorney. So you'll just be required to sign that document. All right. And I've explained to you the options of your pleas of either guilty, not guilty, or no contest. Do you have any questions about those plea options?
No, sir.
All right. If you plead not guilty, let me explain to you what occurs. We'll schedule you for a court date to come back, and that's called a pretrial conference. That's where you'll meet with the prosecutor of the case, and they'll discuss the case. They might provide you the police report and any other evidence they plan on using at a potential trial at a later date. Okay? There's a few options that could result out of the end of that meeting. Number one, the case could in fact go to a trial. Number two, the case could enter a plea agreement that you and all the parties agree on. Number three, the case could dismiss. Number four, you could change your plea from not guilty at that time to guilty or no contest. Or four, the case could be continued by either party for further analysis of the case. That's with a not guilty plea. If you plead guilty or no contest, what will happen is we'll proceed forward into sentencing right here and now, and that'll conclude the entire process of this case. You won't have to come back to court. So that's the options for you to have. Do you understand those options?
I plead guilty, sir,
Okay. I can enter.
because I know what I did wrong.
Okay. I'll enter your guilty plea. Give me a moment.
Yeah, I know I messed up.
That's okay. All right, sir. So what I'm going to do is explain to you the rights that you're giving up with your guilty plea, okay, to make sure you understand them. First off, are you on probation or parole?
Yes, I am.
Which one are you on?
Probation.
All right.
Unsupervised.
Unsupervised?
Yes, sir.
All right. So let me just give you another little information about that. So being that you're on unsupervised probation, this is a misdemeanor allegation. I don't know if it will or will not affect that unsupervised probation. But being that you are on some type of probation, even though it's unsupervised, it does have the potential for your probation to be revoked. That also opens up an opportunity for you to have an attorney court appointed to you at little or no cost. So you can exercise that right if you wish, or you can continue to proceed as you are, knowing that you have that ability. So do you wish to still proceed forward with your guilty plea, or do you want to exercise your right for a court-appointed attorney to see if it's going to affect your unsupervised probation or not, which could be revoked?
Let's proceed.
Okay. All right. All I'll indicate is that I provided you an advisory. All right, sir. So the following rights are what you're giving up by pleading guilty. You're giving up the right to plead not guilty and require the state to prove your guilt beyond a reasonable doubt. You're giving up the right to have a trial in front of a judge. You're giving up the right to have the assistance of an attorney at all stages of the proceeding, including an appeal, and that's what we talked about. You're giving up the right to confront witnesses against you and cross-examine them as to the truthfulness of their testimony. You're giving up the right to present evidence in your own behalf and have the court compel your chosen witnesses to appear and testify free of charge. You're giving up the right to remain silent and to be presumed innocent until proven guilty beyond a reasonable doubt, and also giving up the right to a direct appeal. I want to make you aware of possible collateral consequences with the conviction of this charge. Give me a moment. And those are the following: the possible suspension of your driver's license, an impact on a commercial driver's license or other professional license, an impact on your insurance rates, the revocation of probation or parole, an increased penalty for further criminal charges, becoming a prohibited possessor if convicted of domestic violence charges, and if you're not a citizen of the United States, a plea or finding of guilt may result in your deportation or being denied citizenship or re-entry. Further on your citizenship is Rule 17.2. If you're not a citizen of the United States, pleading guilty or no contest to a crime may affect your immigration status. Admitting guilt may result in deportation, even if the charge is later dismissed. Your plea or admission of guilt could result in your deportation or removal, could prevent you from ever being able to get legal status in the United States, or could prevent you from becoming a United States citizen. Understanding each of these rights I've just explained to you, you wish to waive these rights and enter your guilty plea?
Yes, sir.
Okay. You may file a Rule 33 petition for post-conviction relief, and if denied, file a petition for review. I'll send you a letter that explains that. It'll also explain to you how to set aside the judgment of conviction pursuant to Arizona Revised Statutes 13905 once all the terms of the sentence have been completed, and you may qualify for a certificate of second chance and apply to seal the records pursuant to Arizona Revised Statutes 13911 once terms of the sentence and the time frames therein have been satisfied. The factual basis of your case, sir, is the following from the complaint, is that on August 26th of 2026 at about 8:58 a.m., you were contacted at or near Houston Mesa Road and Caballero Road. That's in Gila County and the jurisdiction of this court. The Gila County Sheriff's Office had contacted you and found that you were operating a motor vehicle on a public roadway while your license was suspended, revoked, or canceled, and you are here pleading guilty today to that charge. Does that sound correct?
Yes, sir.
Give me a moment to catch the paperwork up here, sir. Regarding you entering your plea of guilty, are you doing that voluntarily?
Yes, sir.
Nobody forced, threatened, or harassed you to make that plea?
No, sir.
Did anybody promise you any lighter sentence or punishment that if you pled guilty, you would receive it?
No, sir.
Okay, the court finds that you entered your plea knowingly, voluntarily, and intelligently and will accept your plea. The form that I just reviewed with you is called your guilty no contest plea proceeding. It'll have my initials going down the left column of all the rights that I read to you that you're waiving. It requires your signature on the form acknowledging those rights. I'll also be sending you a copy of the warnings and notices of rights that will explain to you how to set aside the judgment and seal the records that I discussed with you. Would you like to give any statement to the court before we proceed into sentencing?
No, sir.
Okay. Standard fine for a driving suspended, revoked, or canceled license violation is $482. You're credited for 1 day of jail. There's a $69 jail fee, a court security fee of $35.80. A total balance is owed to the court of $586.80. I'm not assigning any additional probation. I am not assigning any further fines. Again, it could have went up to $2,500. So you have a total balance due of $586.80 if you can pay it today. Are you able to pay that fine today?
No, sir. Not today.
Yes.
Okay.
Yes, sir.
Okay. All right. So your family members are here that can pay that balance of $586.80. So I'll show that done by your family members. That's going to save you $20 on a payment plan fee. All right, so this is the judgment and sentencing form. You'll also need to sign that. And I'm releasing you out of custody on your own recognizance. Do you have any questions for me?
No, sir.
Okay, so this will be the conclusion of the case with the payment received by your family members. You'll be released out of custody shortly. I'll explain to your family members where you're at to be over there to receive you when you get out of jail.
Thank you, sir.
You're welcome.
You're going to head on that way.
Counter there.
Sir, step up to the counter, state your full name for the judge, including your middle.
Sergio Compane.
All right, sir, I'll be right with you. Make a copy of this. They're going to pay the fine right now for it. And then if I can get that back when you're done.
Yes.
All right, sir. Let me collect your address. All right. The state is alleging a total of 6 charges against you. 5 of them are felony allegations, and 1 of them is a misdemeanor allegation. I'll first talk about the misdemeanor allegation. All of the charges, you have the right to remain silent, right to counsel, and right to trial. The misdemeanor violation is a DUI charge, and it's being impaired to the slightest degree. That charge is jury eligible, and also you can have a court-appointed attorney if you financially qualify for it. I've scheduled you for an arraignment on that misdemeanor violation charge on the 23rd of September at 9 o'clock a.m. That is where you'll need to be prepared to plead either guilty, not guilty, or no contest to that charge. Depending on how you plead will be what occurs next with the court proceeding, and all of those options as well as the penalty range will be explained to you prior to you giving your plea, so you'll be well informed. Do you understand that?
Yes.
All right. Then the 5 felony allegations that are made that are alleged against you are: number 1, narcotic drug possession or use. Number 2 is dangerous drug possession or use. Number 3 is dangerous drug possession for sale. Number 4 is dangerous drug transportation for sale. And the final felony allegation is drug paraphernalia possession or use. I've scheduled you for a preliminary hearing on the 7th of September on those charges at 4 o'clock p.m. The preliminary hearing is to determine if there's probable cause to charge you with those felony allegations, not convict you. If probable cause is found, then your case will bind over to the Gila County Superior Court, and they'll take disposition of the case. It is possible that the case may go in front of a grand jury prior to that court date, or it's also possible that the county attorney will not file the case. They'll have up to the statute of limitations from the date of your arrest, which is nearly 7 years, to file those charges if they choose not to do it right away. Your release conditions on all the charges are: obey all orders of the court, do not commit any crimes, notify the court immediately of any address change, do not leave the state of Arizona without permission of the court, do not possess or consume any alcohol or drugs without a valid prescription, do not possess any firearms, because these are felony allegations. If you're convicted, you could become a prohibited possessor. Do you understand those release conditions?
Yes, sir.
All right. On the felony allegations, I'm placing a $15,000 bond hold on you, so you remain in custody on the felonies only. The misdemeanor allegation, I'm releasing you on your own recognizance. Being that you're held in custody on the felony allegations, you have the right to a court-appointed attorney at little or no cost to you. If you decide to exercise that right, then there is a financial questionnaire that I'll be sending to you. Complete that questionnaire, and the jail staff will make sure they get it back to us. If you're held in custody, what will occur is if you financially qualify for the court-appointed attorney, then if the complaint files, your attorney will be assigned at that time. If the complaint does not file, then it'll be held until a later time, which your financials will be checked at that time. The other thing that occurs, sir, is being that you're held in custody, the prosecutor has 48 hours from the date and time of this hearing to file a formal complaint against you. If they file that complaint within 48 hours, that's when we'll trigger the court-appointed attorney if you qualify. If they do not file a complaint within 48 hours, you'll be released on these felony allegations on your own recognizance without having to post bond. Do you understand that?
Not quite.
Okay, let me explain it to you a little differently. So right now you're held on a $15,000 bond. The prosecution has 48 hours to file a complaint from the date and time of this hearing, so at 4:10 p.m. in 2 days. If they don't do that, you're going to be released on your own recognizance. Doesn't mean the case is gone. It just means that you're not being held anymore. They have up to the statute of limitations to file the case, okay?
Yes, sir.
If they do file the complaint within that 48 hours and you wish to have a court-appointed attorney and you financially qualify for one, the attorney will be assigned at that time that the complaint was filed. And then they'll be in touch with you. They'll be made aware of your bond amount, of your charges, and they'll be in touch with you a short time after that. Okay?
Okay.
All right. And then we still have the misdemeanor charge that you have to appear on the 23rd of September to plead guilty, not guilty, or no contest. But that's a misdemeanor process. The other one's a different process. Do you understand now, sir?
Yes, sir.
All right. Do you have any questions?
No, no questions.
Okay. That'll be all then. Have a good day, sir.
I'm gonna head on that one. All those directions.